Tipp FM's Tipp Today.
With Slattery's Garage, puck on. It's time to change. Test drive the award-winning range of Peugeot hybrids and fully electric vehicles at Slattery's Garage today. See slatterysgarage.ie.
Legal discussion on Tipp Today is brought to you in association with Lynch Solicitors Clonmel, on the web at lynchsolicitors.ie and at divorceineireland.com.
John Lynch from Lynch Solicitors with me in studio. Good morning to you, John.
Good morning, friend.
And good to see you. We sort of set you a bit of a task this time.
Yes, you gave me some homework.
Yeah, and it's where grandparents are concerned.
Yeah.
Do you want to set the scene for us?
Seeing as I'm a grandparent, yeah.
Me too now.
Yeah, I think the assumption and the question and the whole issue around grandparents is, I'm normally asked the question, what are my rights? And I usually say to myself and repeat it to myself and to others that it's actually not about rights, it's about the best interests of the child, the grandchild. And I think if you start with that in mind, you're starting at the right point or the right position or the right place, because that is the primary consideration of a court. That their absolutely overriding criteria is what's best for this particular child in these particular circumstances. Because, and I mean, I'm not being critical of people when I say that over the years it's always been a very high priority of mine when used to do a fairly significant amount of family law, and it was always my number one priority to deal with the issue of children first and then deal with the other issues. Because, as I used to often say to people, it is the one with the most long-lasting effects post any sort of conflict or separation that arises out of separation. So I think if you start with the best interests of the child as the foremost consideration, rather than come at it, well, I'm entitled to and I should and I have a right to see my grandchildren. If you start with it, what's best for the child? I suppose not an easy one, and not very easy to put into praxis sometimes. But the question that you put to me was a scenario that isn't uncommon, unfortunately, where, and I'm only surmising the situation, if you know what I mean, but where for, say, reasons, whatever reason, a reason of separation, or one of the parents dies, or a situation like that where you're now dealing with, if you like, the in-law parent.
Yes, the daughter-in-law, I think.
The daughter-in-law, the son-in-law scenario.
Yeah.
And if you're dealing with that situation, like, it's a complex situation anyway, but if you're dealing with that type of situation, it wasn't and isn't uncommon that difficulties arise. And the question then comes into me, what are my rights? And I can recite the rights, as in I can tell you what you can do as a grandparent, and I suppose that's the starting point in terms of trying to understand what exactly are we talking about here from a legal point of view now, and we're simply just looking at the legal framework. And the legal framework is that a grandparent is entitled to make an application, and that's important to understand. You're entitled to make the application, you're not entitled to be granted the access privileges or guardianship or whatever. It's not an automatic that if you come into a court of law and say, I'm a grandparent, when do and where do I see my grandchildren? It's not automatic.
Right, so you apply to the courts,
you must apply. You don't get it automatically. Similar to a situation where an unmarried father isn't automatically entitled to custody and or guardianship of a child. You must go into court, you must make your case, and the important consideration here is that when you're making your case, the best interest of the child is the overriding.
And what
criteria.
would the court take into account? This is obviously when relationships have broken down.
Correct.
And you know,
correct.
I mean, you
or if the parents of the child are no longer able to mind the child for whatever reason, either that they're not there, or they might be absent because they died, or absent because they're elsewhere and they're not looking after the child.
Right. In this particular case, I think the son died, leaving behind the young baby. At the start, it was fine with the daughter-in-law. There was no problem. Then she got a new partner, and then things got a bit hairy.
Exactly.
And then they didn't want her to have any access to the child. So in this case, what would she have to prove? I suppose.
Well, in this particular scenario, what the court looks at is the existing relationship between the child and the grandparents. They'll also look at whether, if you allow access, is it going to be in the child's interests? In other words, is it going to be detrimental to the child if you do allow access? They'll also look to the wishes of the guardian and or the other parent and see whether or not will the court override that. Because again, you're talking about, and again, as I say, the emphasis by the courts is not with a view to balancing rights, if you know what I mean, the rights of the parent, the right of the grandparent. It's not a question of balancing rights.
Yes.
It's a question of looking at the interests of the child only. Now, obviously, you have to look to the fact that if you don't have a right of access, you can't apply to the court. But having the right, having been the grandparent gives you the right to apply. It doesn't give you the right it doesn't push you in a position where the court starts saying, well, okay, we're going to measure this out and say, well, there's the rights of the child, there's the rights of the parent, and there's the rights of the grandparent. It doesn't do a measuring exercise as such. In that scenario, it says what's best for the child, basically. It's also relevant, of course, depending on the child's age, what the child thinks.
Oh, of course.
And that comes into play as well. Because
would the child be asked in the court?
Depends on the age of the child, depends on the maturity of the child. Those are the two factors. Age, obviously they're linked. Age and maturity kind of go hand in hand to a certain extent, but obviously it also varies because certain children are more mature at earlier ages than other children.
Sure.
So it's down to the assessment being made by the judge as to whether or not should I listen to the child, should I ask the child. And I remember way back in the early stages of when they first introduced this right of access, I remember one district judge who was very much tuned into and wanting to hear the child. And then there would have been another judge that I would have been dealing with who wouldn't really kind of think to listen to the child at all. Because it's, again, it depends on the judge, depends on the child, depends on the maturity of the child.
And in your experience, John, is it traumatic for the child? Because often the others are at odds with each other, shall we say, the grandparents maybe and the parent. Is that traumatic for the child? Because they have to take a side, I suppose.
Well, it is very traumatic for the child. Yeah. And I remember one of the most contentious cases that I was ever involved in, where ultimately one of the parents ended up in contempt of court and was jailed as a result of the whole scenario. Wow. And it was a very, very, very disturbing case, difficult case, and very difficult to assess, because you had, like, the scenario that you put up to me was very much like parental alienation that talk about, but in this instance there's a suggestion they feel that they've been deliberately alienated and that it's not the wishes of the child and it's not in the best interest of the child that alienation should occur. And the ultimate question is, what can one do about it? Well, if you're looking at a legal scenario, there's two options open to the court in terms of dealing with this type of situation, and different judges over the years have tried different ways of doing it, and then they legislated on it and they said that there is an enforcement option open to the court. And when they handed the enforcement option to the court, the enforcement option they gave was that they could vary the access, they could introduce kind of supervised access, but they could also penalise the non-conforming party in it by charging them a fee or a cost for obstructing access. So that was a kind of, somebody came up with that idea of a kind of a way of monetising the whole scenario. But the ultimate redress of the court is for the court to take the view, and we're all very familiar with this when you read the newspaper when we're dealing with the Burke case, is contempt. And that's the ultimate sanction of any court, is that for the court, if you like, to take it personally and say, you are treating me with contempt. I have made orders here and you have contemptuously ignored them and not complied with them, and I'm there going to jail you. And I've had, only one instance of that over the last 40 some odd, and they're coming up now nearly 40, 5 years now. But I've had one instance of that, and it was so to say it was interesting is wrong, but it was an interesting exercise to observe how that worked, and did it work? Because I remember during one, it was a seminar conference, and I remember putting it to a Supreme Court judge. She was a High Court judge at the time, an eminent High Court judge who dealt with family law. And I asked her, I said, what does one do, or what would you suggest that I do if I'm in a situation where I'm acting for a client where I think the other client is obstructing the whole process and is deliberately trying to block access to children? And the question I asked her is, would you jail that client? Would you jail the person in contempt? And the answer I got was probably not. And it was an interesting thing, because ultimately at the end of the day, I suppose the judge is faced with the situation that if you're in that difficult a situation, does incarceration help? Does it do anything for it?
And where the child is concerned, the effect on the child.
And is it in the best interest of the child?
And John, in this case, it looks like the grandmother went to court, granted access and visitation and the like. But the daughter-in-law and her new partner, they've seemed to obstruct any attempt to at visitation. Or
well, you see, and this is the difficulty. I mean, it's extremely difficult to make any kind of an assessment on a situation like that, where, ironically enough, and I suppose is very legalistic, that you don't have all the facts. And what I'm saying by that is I'm not in any way judging the case as presented or the side as presented. And, the invariable argument that was always put up to me by judges when I was presenting a case where I was trying to establish that there was some alienation of some sort, whether it was extreme or otherwise, was the court judge would always look at you, and whether he said it, you kind of knew what he was thinking. He was saying, well, there's two sides to this, and I have to hear both sides. So, and that, ironically, is the whole essence of a case where one side is making one argument and somebody is making the other argument, that there will be two sides presented, and ultimately the decision as to whether or not there is or is not alienation, the onus, and that's the legal term, but the weight of the evidence has to come from the person making the argument that there is alienation. So in other words, in this particular instance, the onus is on the grandparent to prove this, and that therein lies the difficulty.
Yeah, because she says every visitation has been cancelled to everyone that was organised following the court case, and she hasn't seen the child for over a year. So she's at a junction now here as well, where she either drops the action, I guess.
Well, correct. And the point that you'd make there is that what's really because I thought about this. I've been in this scenario several times over the years, and you look at it and you think, well, what do you do and how do you advise the client? And it's a kind of a mixture of legal and kind of personal advice, in the sense that it's non-legal, and I don't mean personal to me, but it's not legal advice. It's more practical kind of advice is what you end up trying to look at, because you do the best you can to attempt all the non-legal mechanisms. So you try negotiation, you try mediation, you try counselling, try to go through intermediaries, try to go through all the family members. You try and do it softly approach as best you can. At the same time as doing that, you document everything. So in other words, you kind of say to yourself, well, okay, ultimately I'm going to have to approve this. And the only way I can prove it is to document it. So you would have to document each instance and every scenario so that when you sit into a witness box, you're able to say, well, I've made a contemporaneous note of what happened at this visit on this day at this time, and here's my note. This is what, and you can refer to notes in the witness box, and you can prove first of all that you made it at the same time, and you then run down through it and you say, well, on this day this is what happened. Ultimately and invariably, if you do document it with that in mind, and it's not easy to do that, by the way, but if you do document it, then you're in a position to give that evidence when it comes to the point where you have to
And that obviously will make your
discharge.
case much stronger.
Well, exactly. You've got to discharge your onus. The next thing then you've got to probably look at in this particular scenario is to go in on the enforcement mechanism. In other words, your next step up is you go in, if you're at the end, last resort position, you go into court, you explain your case to the judge, you say this is the position, and then overall then, if there's a constant refusal on that, you have to look to inviting the court to treat the other person in contempt. But when all is said and done, and you're able to stand back, if that's possible, and look at it objectively, you say to yourself, if I do all this, is it going to be in the child's best interest? And the parallel advice that I often reluctantly give to a client is, look, maybe you're better off looking to see, can you continue to show, send the cards at birthday time, send the cards at Christmas time, send the presents, and do every possible way of trying to get the message across.
If you and I had this conversation last year, I'd go down and I'd be in total agreement with you on that. But we had a little grandchild this year, and I can't imagine what it would be like to have visitation obstructed in some way, or not get to see them because of the feelings you have for them. So it's tough. It's not easy.
But that's the problem, Fran. How you're asking somebody who's hugely traumatised, who's hugely emotionally invested in wanting to see their grandchild, and asking him at the same time. It's the same question, by the way, that you have to put to a parent that's been obstructed. Yes. It's the same question you have to put. Is it
in the best interest of the child?
Of the mother or the child, or the father who might get obstructed? You're looking at the same thing. Am I doing anything to detriment the child? Is there anything to the child's detriment? Am I actually acting in their interests, or am I acting in my own interests because I want to see the child? Is it better in this situation? It's a bit like the over the years I've been asked, people will come into me and they'll talk to me of the neighbour who's playing loud music, who's throwing rubbish over the wall, who's terrorising them every time they come out the front door, and they say, well, what can I do legally? I said, well, here's all the legal remedies, but your ultimate remedy, depending on what you're dealing with here, might be to move out. And you might say, and they might look at you and go, Jeannie Mac, are you seriously saying that? Well, I'm not. I'm saying to you that ultimately, sometimes you can't go through an obstacle; you have to go around it. And the difficulty with this is it's extremely hard to ask somebody to say to them that over the life of a grandchild, you might be obstructed for a period of 10 years, but the child, after 10 years, then that if you continue to make efforts, that there may be the possibility that there will be a re-engagement with your grandchild
at some
not
future
hard, not
time.
Easy,
not easy.
No, not
all.
easy. And I'm not offering a definitive answer on it because
you're not. But you're still. What you're doing is very interesting. You're putting it to the grandmother to ask herself that question: what is in the best interest of the child, even if it means heartbreak for herself?
Can I hang in there and hope against hope? It's a bit like the district judge that asked me however many years ago, 25 maybe years ago, when I was running a case on behalf of a father who wasn't married to the mother, and the mother was away, not directly involved with the child. The child was being raised by someone else, and the father came in and said, "Well, I'm the father. Can I not raise the child? I'll take time off work. I'll do this. I'll do that, and I'll be available to parent the child." And they refused. Went into court, and the judge said to me about halfway through my argument, he looked down at me. He said, "Mr. Lynch, you do appreciate that you're pushing, what is it, rolling
boulder up a hill."
A boulder up a hill.
Yeah.
And I looked at him. I said, well, I don't know what I said. Well, I think I possibly just looked at him and said, well, if that's the case, I better be careful. It might come back down on top of me. But I mean, the reality of it was that wouldn't be the case now.
All right, John, pleasure as always. Thank you so much indeed for coming into us. John Lynch of Lynch Solicitors in Clonmel. I'll be right back in just a moment.
Tipp FM's Tipp Today.
With Slattery's Garage, Puckon. It's time to change. Test drive the award-winning range of Peugeot hybrids and fully electric vehicles at Slattery's Garage today. See slatterysgarage.ie.